I'm Antonio Neves, The Dot News. The United States Supreme Court has ruled in a case that may have far-reaching effects on how we choose our representatives. The case concerns a process called redistricting, and the specific facts involve a plan by the state of Texas to create 4 new congressional districts. The dispute was over which political party would control those seats. Keisha Gaskins explains.
How we elect our representatives is how we conduct our government. America is a representative democracy, which means how we put those representatives in place is absolutely essential to how our democracy works.
The Constitution created the Senate with 2 members from each state. The size of the House of Representatives has been fixed at 435 seats for the past century, divided after every census to reflect each state's population. This process is called reapportionment. As this interactive map from the Census Bureau's website shows, Texas will gain 4 new seats in Congress because their population dramatically increased between 2000 and 2010. Now, in contrast, New York will lose 2 seats in Congress because the state's population declined. Since each House member represents a single area of his or her state, called a district, Texas officials have to formulate a new map of the congressional districts to make room for the newcomers. This is called redistricting. In most states, redistricting is worked out by the state legislature and the governor. But when one party is solidly in control, it may redraw the map in such a way as to virtually guarantee its candidates will be elected.
I think political parties are incredibly huge players in the redistricting process. Obviously, it is those lines that determine who and how people are elected. So political parties spend a lot of time engaging in a lot of activities to try and ensure a political advantage for one side or the other. And there really hasn't been an effective test in place to see when that behavior sort of goes too far.
For example, a plan can split a community into multiple districts to make sure it can't elect the candidate of its choice. This technique is called cracking. Or a plan can take all the voters that favor the opposing party and lump them all in one district to lessen their impact on surrounding districts. This is called packing. And when race is involved, it's called bleaching.
Look at all this private money changing hands to change these redistricting plans.
The investigative news organization ProPublica has produced a music video all about this.
Redistricting is pretty complicated, and politicians like to take advantage of that. They think it's too complicated for voters to understand, and they can do it sometimes in the back rooms and manipulate things so that they're going to win seats without you even knowing that they're going to do it. And so we wanted to do a redistricting song and a music video to break it down and to show the kinds of stuff that's being pulled behind the scenes.
Most questionable redistricting schemes are often called gerrymandering. It got its name in the early 19th century when the Massachusetts governor, Elbridge Gerry, signed a redistricting plan that unfairly favored his party over the rival Federalist. The newly drawn district looked something like a salamander, prompting some critics to call it a gerrymander.
Gerrymandering has been around since the days of the Founding Fathers. You might think that the Founding Fathers were all like really good and responsible guys, but actually they were totally fighting and trying to outmaneuver each other. And so, for instance, back in the early 1800s, Patrick Henry tried to redraw district lines so James Madison wouldn't be elected to office. And that's the same thing happens today. You see like districts shaped in really strange ways in order to get just the right amount of voters that a certain politician will be able to win office or a certain politician will be drawn out so that they can't win.
All redistricting plans must comply with the Constitution's 14th Amendment guarantee of equal protection under the law. And some states with a history of discrimination must comply with provisions of the Voting Rights Act of 1965. That law requires that all new redistricting plans first be cleared by the Justice Department in Washington.
Under Section 5 of the Voting Rights Act, there are a list of states who must have any voting change, and not just a redistricting map, but any change in their voting procedure cleared by the Justice Department. And most of the states on the list are southern states, Southern states who had a history of denying the voting franchise to minority voters.
The redistricting plan worked out by the state legislature and the governor in Texas created one district which would pack in many of the state's new Hispanic voters. That district would likely vote Democratic. The three other new districts in the plan would be in predominantly Republican areas.
The big question is, if Latino voters accounted for most of the increase in Texas's population, then you might say that at least some of those 4 new districts should be Latino districts.
After the Justice Department objected, the plan was reviewed by a 3-judge panel in San Antonio. They drew up an interim scheme which would give the Democrats 3 of the 4 new districts. Now it was the Republicans' turn to object, and that's why the dispute is now before the Supreme Court. Right now, legal challenges to redistricting plans are pending in about 24 states. And don't look now, but the next census is just 8 years away. I'm Antonio Neves for the Dot News.